Thank you, Madam
Perhaps
Chairwoman.
4 minutes
Less than
maximum.
that.
Thank
In the
you.
interest of saving the committee time, I've prepared very brief testimony. Madam Chairwoman, thank you for this opportunity to testify on House Bill 7222, which would prohibit the state and any of its political subdivisions from, quote, interfering, end quote, with a woman's, quote, personal decision, end quote, to procure an abortion. In effect, this bill would appear to invalidate many existing abortion-related laws in the state of Rhode Island and would prevent the state or municipalities from passing legislation that limits the abortion license or regulates the abortion industry. The bill attempts to enshrine the abortion license as a sort of super right beyond the reach of the law and of this legislature. And as a corollary, it would also have the effect of establishing businesses that provide abortion as a protected class. For example, the bill prohibits the state and municipalities from restricting, quote, the manner in which medically appropriate contraception or abortion is provided, end quote. That could easily be interpreted to mean that abortion clinics are now exempt from regulations to ensure safety and hygiene at medical facilities. If that is indeed the intent or the effect of this bill, it is a clear invitation for the Kermit Gosnells in the world, the famous abortionist from Pennsylvania last year, to come set up their shop of horrors here in Rhode Island, and we believe that this would not be protective of Rhode Island women. Thank you, Madam Chairwoman.
Thank you, Mr. Bracey. Are there questions for Mr. Bracey representing Rhode Island Right to Life? There being none, Susan Yolen.
I'm Susan Yolen from Planned Parenthood of Southern New England, and I just would like to say that this bill really would codify Roe versus Wade, which does not stand in the way of licensing, of regulating, or in any way holding providers accountable to medical standards. We are all held accountable and are licensed and regulated quite often. I wanted to mention the fact that prior to Roe versus Wade, there was a whole generation of doctors who grew up and took their residency and trained in septic wards and hospitals that were filled with women who had experienced the effects of illegal abortions, sometimes ones that they had induced upon themselves. These were many times fatal. If not fatal, they ended women's fertility. Many of these at the time, back in the 60s or early 70s, were married women who had many children already, so it oftentimes jeopardized family life and took mothers away from their children. Roe versus Wade ended this deplorable situation in America. Most young physicians and young women of reproductive age today cannot imagine a world where their most personal decisions wouldn't be honored, where safe care would not only be unavailable, but where accessing abortion would be dangerous and inaccessible only to those with connections, means, and money. So we applaud the sponsors of Bill 7222, and we think that many of the citizens of Rhode Island would as well. Our organization has conducted some very important public opinion research in recent years, and we've learned that the public's support for an individual's ability to make deeply personal, complex personal health decisions remains strong 40 years after the court legalized abortion. The public supports access to accurate information about all options when a woman is facing an unintended pregnancy. The public rejects the notion that information might be provided to women with the intent to coerce any decision. With all due respect, the public also very strongly believes that government and politicians should stay out of personal decisions and refrain from passing restrictive laws aimed at shaming or judging women engaged in complex decision-making. Women don't turn to elected officials for advice about other medical care. We don't ask you whether to get a mammogram, a cancer treatment, or prenatal care. And most of us don't think that elected officials should be involved in legislating how women make personal medical decisions regarding their pregnancies. So we urge you to pass Bill 7222 and join other New England states, including my home state of Connecticut, which codified Roe v. Wade 25 years ago. The bill that you see before you is a framework that reflects the holdings of Roe v. Wade, which has stood the test of time. The question is, will Roe stand the test of time? And our keenest warning is the recent Supreme Court ruling on the Voting Rights Act. a long-standing policy that empowered a generation of previously disenfranchised voters that was overturned by the court just last summer. Could Roe be reversed as well? We would be foolish to assert that it could not, given the current makeup of the court. And that's why other states, including my own, have acted to codify the holdings of Roe in state law. Overwhelmingly, Americans agree that decisions about whether to choose adoption, end a pregnancy, or raise a child must be left to a woman, her family, her faith, with a counsel of her doctor or a healthcare provider. Making certain that Rhode Island statute protects the women of our state to make health decisions without penalty or risk is both a public health and a moral imperative. So we urge you to pass Bill 7222. Thank you.
Ms. Yolen, I noticed that you said my own state. You are a resident of
I am a
Connecticut?
resident of Connecticut. However, I do a great deal of work here in Rhode Island, and Planned Parenthood of Southern New England is in both states, Connecticut and Rhode Island.
Thank you.
Thank you.
Questions from the committee? There being none,